Okay, thank you.
Good morning, good afternoon. I think it's a minute after 12. Mr. Evans, thank you very much for the opportunity to present to your students and introduce them to this lovely subject called intellectual property. My name is Mujalefa Koza. I am with CIPC and I am a senior education specialist, and my responsibility is to develop and to implement all programs on intellectual property, which is the subject of my discussion with you today. CIPC is an agency of the Department of Trade and Industry and Competition in Pretoria. As you would know, the department has many agencies and we are one of them. Now, my presentation today will focus on these bullet points. One, I am going to introduce to you my establishment, which is CIPC, and what we do. And I'm going to talk about the legislation that we administer as an establishment of government, but only as far as intellectual property is concerned. We're not going to talk anything about companies today. Then I am going to define and unbundle and break down the concept intellectual property. From there on, I will delve into the different types of intellectual property so that you can begin to see and appreciate their differences and how they relate to one another, and how you can actually take advantage of one or two or three or all four types of intellectual property. Finally, something for you to consider: a career in intellectual property since you are business students. Now, this is who we are. CIPC, it's an acronym for Companies and Intellectual Property Commission. And we were brought into existence when the Companies Act 78 of 2008 was amended. And officially, we began to be an office on the 1st of May 2010. Now, if you look at that, at the acronym CIPC, you can see that in our name, there are two components there. One, it's companies, and two, it's intellectual property rights. That's why our name is CIPC, which stands for Companies and Intellectual Property Commission. And at the head of the office is our commissioner, who is the registrar of the commission. What does CIPC do? CIPC is the only registration office of companies in South Africa. We register all types of companies, your private companies, your public companies, your personal liability companies. We also register what we call non-profit companies. We also register state-owned companies like your ESCOMs. And on the other hand, we register intellectual property rights. And this is the subject of my discussion with you today. Number two, we disclose information on our register. For example, if company X wants to do business with company Y, and they want to know if the company is legit, if the company is truly registered, if the company is compliant, it pays its annual returns and it submits its annual financial statements. Upon request, we can give that information. And then we enforce all the legislations from the companies to the intellectual property legislations. Then Section 288 of the Companies Act has given us another mandate, and that is to do education and awareness on companies and intellectual property. In other words, we are mandated by Section 288 of the Companies Act to go around and talk to South Africans about companies and intellectual property laws. We do licensing of business rescue practitioners. Business rescue practitioners are all those professionals who have the experience, the qualifications, the know-how of turning the fortunes of a company that is not doing well. Most of the business rescue practitioners that are licensed with us are former CEOs of companies. Now, if you think you have what it takes to become a business rescue practitioner, you can apply with us and we will give you a license to rescue all those companies that comes to you and wants a financial turnaround. We monitor compliance, we do research, and upon research, we advise our minister on matters of national policy as far as companies and intellectual property law is concerned. And finally, our mandate has been extended to accredit and to regulate collecting societies in music. Now, what are collecting societies? Collecting societies, one, are non-profit organizations. They are accredited by CIPC. They are regulated by CIPC. Now, what do collecting societies do? They represent their members. And by the way, their members are artists, musicians, and record companies. What do they do for their members? One, they give out licenses on behalf of their members to the users of their music. And the users of their music are radio stations, retail stores, airlines. In other words, collecting societies are the people who goes to all retail stores and say, you can play the music of our members. They go to radio stations and say, you can play the music of our members. We call it needle time. And there is a certain fee that you have to pay every time you play a member's song. That kind of money, we call it royalties. And they negotiate tariffs on behalf of their members. Tariffs simply means how much every time a song is played. So in a practical sense, if Radio Metro plays Casper Nyove's song 500 times over a period of 6 months, they have to pay each and every time they play the song. And what collecting societies do on behalf of their members, they collect this money that we call royalties over a certain period of time, usually 6 months up to a year, and after which they distribute the monies collected, that is the royalties, accordingly. But before they distribute, we want to see the distribution plan as CIPC and see if the distribution plan, the data collected talks to the money that has been distributed. So in a nutshell, those are the functions of CIPC. Now let's talk about the legislation that we administer as far as intellectual property is concerned, starting with the Copyright Act, number 98 of 1978. Now we administer this legislation, and this legislation is the legislation that protects all literary, artistic, and creative works. Now, what are artistic, literary, and creative works? Here we're talking about things like music, lyrics for a song, a script for a movie, paintings, photographs, films, anything that is artistic, anything that is literary, anything that is creative is protected by the Copyright Act. Then related to the Copyright Act, we have a legislation called the Performance Protection Act. And what does this legislation protect? It protects performances in music. It protects performances in films. In other words, in a musical production, that singing, it's called a performance, and it's a right, and this right is protected by this piece of legislation. And in a film, all those people who are acting in a film, that acting is referred to as a performance, and it's a right that belongs to the performers or the actors, and it's protected by the Performers Protection Act. That is why we call it a related or a neighboring act to the Copyright Act. Then we have the Patents Act. This is the legislation that protects your inventions or your innovations, whether those inventions are new and whether those inventions are technical or non-technical, whether they are technological or non-technological, as long as it's an innovation or an invention. And usually that invention must be new. In other words, it must be an innovation that has not been done by anybody else. Then we've got the Designs Act. Many people still do not know that designs are regarded as a product of intellectual effort and are therefore protected by this legislation. And when I'm talking about designs, I'm talking about designs of any kind, from fashion, that is clothes, furniture, motor vehicles, cell phones, all those designs are protected so that nobody can copy those designs and make money out of them. Then finally, we've got what we call the Trademarks Act. Now, this is the legislation that protects your company names. This is the legislation that protects your company products. This is the legislation that protects your company's slogan and your company logo. Now, if you have a company registered with CIPC, our advice is apply for a trademark and protect the name of your company, the logo of your company, the slogan of your company, and even the names of the products that belongs to your company. Because if you don't, people out there might use the name to make money out of the products that your company owns. And colored in red, down, we've got 3 international agreements that as South Africa has entered into as far as intellectual property is concerned. One such international agreement is the Berne Convention. This is an international agreement that protects copyright works in the countries who are members of the Berne Convention. And by the way, South Africa is a member of the Berne Convention. What it actually means is we are duty bound by our membership of this convention to make sure that we protect music from America, from Europe in our country, and they are also duty bound to protect South African music in their various countries, and we are a member. This age-old copyright international agreement was signed in a city called Berne, in Geneva, a city called Berne in Switzerland, I'm sorry. And then we've got the TRIPS agreement of 1994. We are also party to that. And this is where member states of this agreement agreed to trade equitably as far as intellectual property products are concerned. And then we have the Paris Convention. This is an agreement that was taken a long time ago, and South Africa is also a member of this convention. And this convention was solely about the protection of industrial designs. And then finally, we are a signatory to the Patent Cooperation Treaty of 1970. This is a treaty that was taken at the international level for the protection of patents in all the countries who are member states to this international agreement. Now, let us go to the topic of the day and try to unbundle what intellectual property actually means. Well, there is an internationally accepted definition of intellectual property. It simply refers to the creation of the mind. But then when we talk about the creation of the mind, what are we actually referring to? I'm going to give you an example. If Mojalefa uses his mind and come up with something that is new, that something will become Mojalefa Khoza's intellectual property because he has created it using its mind. So intellectual property, it's like, any other type of property, except that this type of property, it's a property that has been created by the use of the mind. And those creations might be a process. Those creations of the mind might be a product, and such products might be inventions or innovations. Such products might be literary and artistic works like paintings and photographs. Such products can be designs of chairs, designs of clothes, and such products might be company names or images of a company like a logo. Now, if you look at the bottom of my slide, intellectual property always starts with an idea. All these products, all these processes that are available to us as South Africans are the result of ideas that came from different people. However, when you have an idea, you don't come to CIPC and ask for protection for the idea, because we don't protect the idea. We protect the results of the idea. And the results of the idea might be a product, might be a process, might be a book, might be a designer chair, might be a name of a company. So when you have an idea, all you have to do is start working on that idea, thinking out of the box, innovating that idea. Because if you don't, chances are you'll take that idea with you to the grave. And that idea, that is the idea that could have changed your fortunes as an individual. And that idea could have been an idea that would have benefited South Africa and the rest of the world. Now, if you look at this slide, it tells you that out of the creations of the mind, we use patents to protect inventions. We use copyright to protect music, books, literary works, television programs, documentaries. We use trademarks to protect names of companies. We use designs to protect designs of any kind, as long as those designs are new and it is not a copy of somebody else's designs. Now, these are the 4 types of intellectual property that I spoke to you about in the previous slide. One is a patent. I have deliberately used a cell phone just to illustrate to you what we mean by a patent. If you look at the cell phone and ask yourself, what is the patent in the cell phone? The answer is simple. The patent in the cell phone is the technology that is inside the cell phone that allows you and I to communicate wirelessly wherever, whenever. And if you look at the cell phone again and ask yourself a question, would there be a design in a cell phone? The answer is yes. If you look at all these cell phones, they look the same, but the designs are not the same. So the owners of these cell phones, they protect those designs worldwide, including South Africa. And again, if you look at the cell phone and ask, is there a trademark in a cell phone? The answer again is yes. And what could be a trademark in the cell phone? The trademark in the cell phone is the name of the cell phone, like Nokia, like Samsung, like Huawei. A trademark simply means a protected name. So all these companies, they protect the names of their cell phones worldwide. In other words, even if you can come up with a new cell phone, sometimes in the future, you've got to find a name for your new cell phone. You cannot use the name Nokia. It's protected as a trademark. You cannot use the name Huawei or the name iPhone or Samsung. And finally, if you look again at cell phone and ask yourself a question, is there copyright in the cell phone? The answer again is yes. The question is, what type of copyright do we find in a cell phone? The most common type of copyright that we find in a cell phone, it's the manual of instruction that comes with the cell phone, because it is regarded as literary works. Literary works simply means anything that is written down, like a manual of instruction, like a book, like a novel. like lyrics for a song, like a script for a movie. So this slide illustrates to you that in one product, you can have 1, 2, 3, 4, or even 3, or even all these 4 type of rights. And if your product or your process has all those, you can take advantage of all these legal frameworks and apply for protection using all 4 types of intellectual property. Now, let us go into these 4 types of intellectual property in detail, starting with a trademark. Why is it important for you to come to CIPC and apply for a trademark, even though your company it's still new, it's still relatively unknown? It is because a trademark has a purpose, and the purpose of a trademark is to protect your brand name, your company name, your slogan, or the logo. And a trademark, it's important because it helps you to identify your goods and services from the goods and services of your competitors. It helps you to stand out and say to your customers, this is who I am, and I can give you better quality goods or better service than my competitors. A trademark also helps you to build your own brand and to protect that brand against unlawful usage. Now, how can you protect a trademark? You can visit us on www.cipc.co.za and apply for a trademark online. But before we do, we advise you that you conduct what we call a trademark search. And why are we recommending that you do a search first? It is to check if somebody has already applied for the trademark that you have in mind. In other words, it will save you time, it will save you money. If you find out that before applying, somebody has applied for the same trademark as you, save yourself time, change the trademark, because we are going to decline it on the basis that somebody else has already applied for a similar trademark and it was granted. Okay? Now, this is the reason why we are saying protecting the name of your company, protecting the name of your brands is important. And this is because of a landmark trademark infringement or trademark case study that we use to illustrate the importance of applying for a trademark with CIPC. And this landmark case study happened after 1994 when South Africa was readmitted to participate in international sports, in rugby, in soccer, in all these sporting codes. Now, the name Bafana Bafana came up. Where does it come from? I don't know. But what I know is, as South Africans, we started to call our national local soccer team Bafana Bafana, which means the boys. Now, this name started growing as a brand. It started becoming a very strong brand. Probably in about 5, 6 years, all South Africans knew that when you speak about Bafana Bafana, you're speaking about the South African national soccer team. And this brand started growing outside the borders of South Africa into Africa, Europe, Asia, and the rest of the world. However, the South African Football Association made a mistake of their lives, a mistake that was to cost them dearly. And the mistake that they did was they did not take this name and apply for protection with CIPC as a trademark. And that mistake was noticed by this gentleman, Wayne Smith, who is, by the way, a South African who owns a company called Stanton Woodrush. He realized that SAFA has not actually protected the name. So in intellectual property terms, if it's not protected, it's up for grabs. And what he did was, in 1993, he went to CIPC, did a trademark search on Bafana Bafana, and when the trademark search report came, it stated that the name has not been protected, therefore nobody owns it. He took advantage of this mistake, applied for a trademark and was granted in 1993. I was not working for CIPC then. I was still working for Standard Bank, and he was granted. Now, as the story goes in the media, this guy, obviously now he is legally the owner of the trademark Bafana Bafana. Obviously, he waited for the right moment. And the right moment came in 2010. Remember when we won the rights to host the most prestigious soccer tournament in the world, which is the World Cup. And we are told in the media in 2010, when we were hosting the World Cup, you all remember the excitement. SAFA obviously started advertising the tournament in the media, and we are told that this guy approached SAFA and stopped them from using the name Bafana Bafana in any of their media advertisement. But we are told in the media that an agreement was reached between Wayne Smith and SAFA, and he licensed them. In other words, he gave them permission to use the name Bafana Bafana in their advertisement for the duration of the World Cup, which is a month, and we are told he charged them a cool 3.8 million. Then after the World Cup, SAFA had two choices. After the World Cup, SAFA had two choices. Somebody's talking. So after the World Cup, SAFA had two choices. One choice was to abandon the name Bafana Bafana or to buy it from Wayne Smith. Now, at that time, you can understand why SAFA decided to buy it, because at that time, it was a big brand. If you abandoned it, it means you had to start now and giving our South African soccer team a new name and start spending money and building the brand. Now, you can see in this slide that the mistake that SAFA has made of not applying for a trademark and protecting this logo and this name cost them dearly, because at the end of the day, they reached an agreement and he sold them the trademark for a cool 5 million rand. So you can see that this mistake has cost SAFA dearly, and this guy was clever, and look at how much money he made. And how much did he pay to register a trademark? He only paid 590 rands, and he only paid 190 to do a trademark search. So while your company is still new, apply with CIPC, protect it. You'll never know what will happen in the next coming 10 years. Now let us talk about a patent. A patent, just like a trademark, will give you an exclusive right over your invention, provided your invention is new, provided your innovation is new. And sometimes an invention can be a product, or sometimes an invention can be a process. Now, all these types of intellectual property gives the owner an exclusive right over their intellectual property. Now, if you look at the bottom of my screen, I have used cosmetics and hair products to illustrate what I mean by the patent. The patent is actually what's inside those containers. I don't have, an appropriate term to use, but for the purpose of our discussion, let's say the mixture or the concoction or the recipe of this hair and beauty products. Now, sometimes a patent can be a process and not necessarily a product. And if you look at all these cosmetics or hair products, you can see that there is not only a patent, you can see that there is a trademark, you can see that there is a designs. The designs for those containers are protected. Now, in South Africa, when you apply for a patent and you are granted, it's going to give you protection for a period of 20 years, after which it goes into the public domain. Somebody can use it without your permission because the protection has lapsed. Now, here is a patent that we granted recently. It's a South African patent. And if you look clearly at the screen, you can see that this is a candle holder. Now, the lady who designed this candle holder is a South African, and she applied for a patent, and we granted a patent because this product meets all the requirements of a patent. And the reason why this lady decided to come up with this kind of a candle holder, it's because in 2019, I think somewhere in George or Neisner, there was an informal settlement that bent to ashes because somebody uh, forgot the candle with a candle holder, and it was still lightning. And it is because of this tragedy, because about 1,000 shacks were burnt to ashes, and not only in Neisner, I think in Cape Town as well, Khayelitsha, a terrible accident like this happened. Now, it is where this lady got an idea to come up with a candle holder that does not easily fall, that is strong. If you can see, it's got 3 legs, and if you can see in the middle, it's got a hole where you slot in the candle, and that candle holder, it's tight, so it means it is safe. So, because this lady came up with something that is new, something that somebody has never made before, and which is a requirement for a patent, we granted this lady a patent. Now, it means now all those people who lives in informal settlements can now buy this candle holder because it is safer. This is the patent application, and that's the example of the patent that we granted. Okay, now for us to grant you a patent, there are 3 requirements that CIPC looks at. 1, it must be new. That's novelty. Number 2, you must disclose to us the inventive steps from A to Z. Number 3, it must be commercially useful. In other words, it must be a product that is needed by the market. And if you look at that candle holder and ask yourself, is there a market in South Africa for such a product? The answer is yes. But because there are places out there that still do not have electricity, not only in South Africa, but in some other African countries. I am not sure about South America and Asia. Okay. Now, the most important word that you should consider in this slide is the word territorial. We are saying patents are territorial. In fact, all these 4 types of intellectual property are territorial. But what do we mean when we say patents are territorial? What we mean is that if you apply for a patent in South Africa and it's granted in South Africa, your protection is in South Africa only. In other words, if you want protection in Botswana, in Nigeria, in the US, you have to apply for a patent in those countries also. And that is subject to their national laws and their national fee structures. So don't take it for granted that when you are granted a patent in South Africa, the protection applies elsewhere. Okay? How do you register a patent? You go to our website, you do a patent search, you file for a provisional patent, which is only 60 rands, and this one you can do without the services of a lawyer. Even a trademark, you don't need a lawyer, but you can use the services of the lawyer if you want, but the law does not forces you to do that. And then after registering a provisional patent, after a period of 12 months, you need to apply for a complete patent. Now, this is where the difference is. A complete patent, according to the patent law, you've got to use the services of a qualified patent attorney. This one you cannot do on your own, okay? This one you cannot do on your own. And a complete patent will cost you 590 with CIPC. However, remember that the attorneys will also add their fees. They will add their fees. A design. A design is all about protecting the shape, the pattern, the configuration of a product. I have used earrings to illustrate what I mean by designs. but designs will go far beyond earrings and jewelry. And we've got designs of chairs, we've got designs of clothes, we've got designs of beautiful motor vehicles. All those designs are protected all over the world. Sometimes companies or people protect designs for their look. We call them aesthetic designs. Sometimes they protect them for their function, like a screwdriver that you see. But sometimes they protect them for both. If your design is there for the look and the function, then you can apply for both the aesthetic design and the functional design. Now, here is a young guy. He's a South African. His name is Zonke Zamandaba. He's from the province of Gauteng, and these are his beautiful designs. I am particularly in love with his toaster, and look at that. It's something that is very nice and something that is breathtaking. This young guy applied to protect his designs, and if you look at the top right, it was in 2018, and that's the design registration number we granted because it met the requirements for us to grant him a design. And we also want to talk to this boy to say, because you call your product Zianda, why don't you apply for a trademark and also protect the name of your products? And we also want to call that lady who came with the candle holder to say, you have applied for a patent, but we can see a design here, and you can give your candle holder a name and also apply for a trademark. The more you apply for all this intellectual property, the more you add protection towards your intellectual property. Okay, now these are the registration requirements for a design, and they should be new. Those designs, it must not be a copy of somebody's design. Then when you are granted, you are required by the designs law to renew your designs annually from the third year. In other words, if a design is granted today, it means in 2028, you now have to start renewing your protection on an annual basis. Now let us talk about the final type of intellectual property, my personal favorite, and that is copyright. But before we start with copyright, let me make you aware that copyright is very tricky. Copyright is very complicated. It is quite different from all the other three types of intellectual property that I've spoken to you about. And the reason why copyright is complicated or tricky, it's because unlike a patent, unlike a design, unlike a trademark, copyright just does not give you only one right. It can give you a bundle, meaning it can give you more than one right in one copyrighted work. And I'm going to use music to illustrate exactly what I'm talking about when I talk about a bundle of exclusive legal rights. And I'm going to use music. For example, let us say Mujalifa, it's a gifted lyricist. In other words, I'm gifted in writing songs. When I take a piece of paper and write a song, meaning write the lyrics for a song, that right belongs to me, and that right is called literary rights. And then suppose I approach Mr. Evans, because Mr. Evans is a gifted composer and he composes the melody or the music or the beat, as we call it. That's another type of right. We call it musical right. And the owner of that right is Mr. Evans. And then let us say we approach Tsepo to sing, because Tsepo has a beautiful song. That singing, it's called a performance, and it's a right that belongs to Tsepo, and it is protected by the Performance Protection Act. Then into the value chain comes now the record company. We don't have money to record. We approach somebody who has a record company. The company that has a studio, will take my lyrics, will take Mr. Evans' melody, will take Tsepo's singing, which is a performance, and put them into a CD. Now, in terms of the Copyright Act, do they own a right? The answer is yes. They own a right that is called fixation or mechanical rights. Now, you can see that in one copyrighted work, there is 1, 2, 3, 4 types of copyrights. That is why we say copyright gives you a bundle of exclusive rights. In a movie, the same thing applies. In the movie, the same thing applies. Somebody would write the script. He owns that right. It's called literary work. Those who act in the movie, it's a right that belongs to them. It's called performance. And then there comes the producer with the money to shoot the film. He owns the film, but not what's inside the film. And then sometimes in that film, you might want to use somebody's song as 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 a soundtrack. That song might have been written by 1 or 2 or 3 people. If it's written by 3 people, it means you've got to get permission from all 3 of them to use their song as soundtrack, and obviously you've got to discuss how much. So that's what I mean by a bundle of rights. That is why when it comes to music or when it comes to film, when the money starts coming in, there's a lot of fight because everybody deserves a little for their contribution. And more than 2 or 3 people own those rights in a film or own those rights in a song. So, practically doesn't always happen that way. 9 out of 10 times record companies wants to take the chunk of the money, and they would put a contract on the table. And if you're not careful and you don't understand the contents of the contract and the clauses that are in there, you might find out that at the end of the day, you have given ownership of your rights to a record company. Sometimes a record company would put it straight and say, if we record you, we own anything. Take it or leave it. So the choice is yours as the right owners. Now, here is a beautiful copyright story that I like to use as a case study and to illustrate that you should respect somebody's intellectual property right. Here is a young guy by the name of Anthony Villa. He comes from a township called Tembisa here in Gauteng. He is a gifted painter. He paints beautiful pictures for a living. You can check his paintings on Instagram. That's where he puts most of them. You can check them on all the social media platforms. So what happened is Nando's, one of the biggest, fast food outlet in South Africa, saw those beautiful paintings on Instagram. And what they did is they took the paintings and used the paintings in their advertisement. And this act was noticed by this man, who is, by the way, the owner of the copyright owner of these paintings. And we are told that he approached Nando's and took them head on. And Nando's never even wanted to go to court. They decided that they are going to settle out of court. And you can see the reason why they made that choice, because why would you want to go to court when you know you're going to lose? First, this guy is the copyright owner of the paintings. Number 2, Vodacom never got permission from him. They never spoke about money, how much, and stuff like that. How much did they settle this young guy out of court? We don't know. But how did we get to know about the story? We got to know about the story because in one of our workshops, Nando's came with this young guy to tell us the story. And the reason why they were using this story was to make the audience aware that you should respect people's intellectual property. If you want to use somebody's intellectual property, you've got to get permission from the owner. You've got to get permission from the owner. Now, this script shows you those bundle of rights that I was talking about them. There are 9 all in all. Those bundle of rights are protected by copyright. Anything outside this list is not protected by copyright. Copyright protects musical works. Those are compositions. It protects literary works. Literary simply means anything that is written down. Your books, your novel, your scripts for a movie, lyrics for a song. It protects artistic works. These include your sculptures, your paintings. I always forget to include architectural drawings. Architectural drawings in our country are also regarded as artistic works and are protected by copyright. It also protects computer programs. Please call me. You know the story. Published editions, whether in books or in music. Broadcast, there is audio visuals, that's radio and television. Your programs carrying signals. Sound recordings, that's the CD. But now the CD is out of use, and music can be stored on a USB. That's a sound recording, okay, or on a computer. And then films, those are movies, those are videos, those are documentaries, those are music videos, for example, they fall under this category. And down there you can see there's performance. It's not protected by copyright, but it's protected by the Performance Protection Act. And we find performance in music, we find performance in films. That's why we call it a related or a neighboring act. Now, this is what I'm talking about. This is performance in music. In a song or in a CD, let us look in the middle. In the middle are the rights and the right owners. In the middle, you'll find the composition, you'll find the lyrics, you'll find the performance by a singer. Obviously, the name of the song is a trademark. Those are right holders. Now, if you look at the top left, then comes the record company with the money. And because they've got the resources to record, they will record. But what changes everything? What changes everything is on the right, the law of contract. Usually record companies will put a contract there. And if you check most of their contracts, there would be a clause that says, if we sign you guys, then we own everything, meaning we own the composition, the lyrics, and even the performance. And the reason why they always get away with it, it's because of the desperate situation of people. They say, take it or leave it. So when you are into the music space, before signing a contract, please make sure that you read through the contract. If you don't understand, get somebody with a legal background to help you understand it, so that you make sure that you enter into a contract that will ensure that you still own your rights in music. The same thing happens in films. If you look in the middle, those are the bundle of rights, and those bundle of rights are owned by people. And then comes the producer at the top. And then on the right, the contract changes everything. So sometimes you are desperate. Sometimes it's not because you are foolish, but sometimes it's because you just want a break. So when production company says, here is a contract, but we own everything, sometimes don't be stubborn because you're a beginner. Sometimes I accept the terms, so that now when you become established, you can now change the contents of the contract and say, this I don't want in the contract. This I agree with. Take it or leave it. And at that time, you'll be established. They will have no choice. This is what I'm talking about. This is a stage act. All those actors, this acting is called performance, and it's owned by the actor. However, contract changes everything. Here is another one, performance in front of an audience. Okay. Here is another one, performance in a recording studio. So those are the things that you should always be on the lookout for. Now, here's another thing that makes copyright very complicated. Unlike trademarks, patents, and designs, you don't register copyright. The law, the Copyright Act, gives you automatic protection. Once you write a song, it's automatically protected. Once you write a book, it's automatically protected. However, this is very problematic. Problematic in a sense that when there is an infringement, you might find it difficult to prove ownership in the court of law. That is why, in the absence of the registration process, all those countries who are members of the Berne Convention, including South Africa, decided we want to put together a depository system for all copyrighted works, so that when you have written a song, you can go to the copyright office, deposit it, and get a reference number that shows that you are the owner. Anybody who wants to use your song will have to contact you and get permission from you. So far, America has done it. In 2019, we went to Washington, to the Copyright Office of America, to see how they've put together this depository system for all copyrighted works. And we also went to Kenya in 2017, I think, because Kenya is the only country in South Africa that has a depository system for all copyrighted works. Now, as South Africa, we also want to establish that depository system. That's why we went to them, so that they can show us how they actually do it. However, in the meantime, even though all these types of copyright receive automatic protection, the only type of copyright that we register so far as CIPC is films. But we only register a film once it's shot and it's completed. But in the coming years, we also want to register all this type of copyright. So people are always saying, if films also enjoy automatic protection, why do you as CIPC register them? And the answer we usually give them is that, yes, we know films also enjoy automatic protection. But when you register for a film protection, we give you a certificate that shows that you are the owner of the film. So when there is a problem or somebody has copied your film, it's easy to show the court that certificate that shows that you are the owner of the film. Another thing, when you apply for film registration, we want you to clarify the roles of all involved in the film. And that would help if there is an infringement in future. For example, we would like to know who wrote the script. Is it one person who wrote the script, or was the script written by two people, in other they co-authored it? Who are the actors? Okay, and the soundtrack, who does it belong to? This kind of information will help you in the future if there is a dispute. Films enjoy protection for 50 years from the year of publication. And this is how you register a film. You go to our website and you register as a customer, just like you do when you register a company, and you create your own password. The system will create a customer code for you. You deposit funds, it's 510. Then you go to online transacting, to IP services, and you apply for a fee. You apply for a filling. Okay? Yes. These are the benefits that I have been talking to you about of registering a filling. And I think I have come to the final slide. And this is something for you to consider as a student, a career in intellectual property. This is quite an unexploited territory, and I would advise you to take advantage of this space. You can become an IP lawyer. You can specialize in patents, copyright, trademarks, or designs. You can be a patent attorney. But for you to become a patent attorney, what do you need? One, you need a technical degree. And what is a technical degree? It's a degree in science, physics, chemistry, engineering, biophysics, biochemistry. And when you get that degree, you also need a degree in law, an LLB degree. Then, after you get your LLB degree, obviously, you would be a candidate attorney at an IP firm, not any other firm. You go to an intellectual property firm like your Spoor and Fisher, your Adams and Adams, your DM Kish, those are the big guys. And you become a candidate attorney, get some experience, sit for board examination, and become a qualified patent attorney. There is money there. You can also be a copyright lawyer. This is where you can represent your musicians like your Casper Nyovest, yeah, like your Tyler, you know, and you'll take care of their copyright. You can be a trademark lawyer where you actually will be working with companies and taking care of their intellectual property portfolio like trademarks and designer. You can be a music composer. In America, there are people who just compose the music. They don't sing, they just compose the music, the beats and the melody, they sell it to the musicians and make a lot of money. Or you can establish a recording studio and record young, upcoming, and established artists within South Africa and outside the borders of South Africa. You can be a publisher, a publishing company where you publish books or music. You can be a filmmaker or a film producer. If you look at channel 320, channel 0320, most of the Amapiano music videos are produced by a young guy called Monde Dube. Most of them you'll see at the end, producer Monde Dube. This young guy is making money producing all these music videos that we see. I think I have come to the end of my presentation, Mr. Evans. Let me stop right there for questions and for comments. Thank you. Hello, are you still there?
Loud and clear. Hi there, sir.
Okay.
Can you hear me?
Yes, I can hear you loud and clear.
So I have a question, right? So
Yeah.
I recently started a small laser cutting business industry, and I have a few templates that I would like to patent in terms of my design and idea. The question that I want to ask is, if I patent a design, right, and should in, let's just say, maybe 6 months down the line, I come up with a new design in terms of shapes, I'd use a random shape that I think that might be nice. Does it mean that I have to update my patent design again and then pay another fee, or how does that work?
Okay, I think I understand.
You're breaking up there, sir.
Yeah. Can
Can
you
you
hear
hear me? Yeah, I think just closer to the microphone.
Yes. Can you hear me now?
Loud and clear.
Yes. You don't use a patent to protect designs, but
Okay.
you use designs to protect designs. And yes, if you have templates that you have designed, you can protect the designs of those templates. And if there are 6 months down the line, you want to make modifications to your templates, that is allowed. It's called amendment.
Okay, so it can be done. And the process is if I after this if I contact you and I want to go do the registration for like 6 months or so and do the application process, um I hand over the files to you, and then we start making what is it? What do you call it? Copyright on the design. Is that correct?
No. Designs are designs. Copyright is something different.
Okay, so on design.
Yeah, what you do is once you think you've got designs of templates that you want to protect, you go to our website. You don't give us the files. You
Okay,
go
cool.
to our website, you apply to protect those designs. Obviously, there will be somewhere where it says upload those designs because we want to see them, because we cannot protect what we don't see. You will
100%.
keep the originals, and the uploads will come to a CIPC via the system to the designs registration unit, and they will process your applications and grant you.
And roughly in terms of protecting the files, assume I want to get this protected ASAP, and in order for me to launch my product into the market and expand, roughly what's the turnaround time?
Well, the turnaround time for designs, it's probably around between 2 and 6 months. Because what happens is once you do your application online, they take those designs, they put them into the patent journal for a period of 3 months to see if there are no objections. If there are no objections after 3 months, they go ahead and grant as long as they meet all the requirements.
Okay. Then the other one is registration of a business name and slogan.
Yes.
Can that be done with you?
Yes. It's called a trademark.
$100.
If you want to protect the name of your company, the names of the products of your company, your slogan, and your logo, it's don't do it separately. Do it as one package. Because if you do them separately, we're going to charge you a separate fee for each. So once you bundle them together and upload them when you do your application, you're going to pay only 590 for all four of them.
And then that gives me a registered business title. Am I correct with my slogan?
It gives you a registered trademark for your company name, the products of your company, the slogan of your company, and the logo of your company.
So, which means no one in South Africa can use the same name or logo or
Exactly.
slogan. 100%. Okay, I'm with
Exactly.
you.
Exactly. Anybody who uses your logo, your slogan, you can take them on.
Okay, 100%. Okay, then I would definitely be doing that. If it's possible, am I available maybe after the session or maybe whenever you are available? Could we schedule a meeting where we can work together in terms of registration?
Okay. In that case, I will have to refer you to the trademarks registration office.
$100.
I'll give you a contact because those are the ones who do registration. Then you can schedule a meeting with them. Then they can show you how. So
Ah, cool.
if you can drop me an email, I will give you a contact for our registration office for trademarks and for designs. Those are the guys that you need to schedule a meeting. They will take you through the registration process.
Okay, cool. Thank you so much, sir, for your time. It's really been a pleasure taking notes from you. And yeah,
Thank you. Thank you.
bye.
Good afternoon, Mr. MJ.
Hi, how are you doing, sir?
Find yourself, sir.
I'm okay, thank you.
I have three questions. Ne?
Yeah.
Firstly, I have a production company that is going through the deregistration process.
Okay.
So I don't know which route must I take regarding for bringing it back. Because at the present stage, that stage that is at, I can't amend anything. So
Okay.
I don't know
I ha-
what to do.
I have one question for you. Did you get a message that says your company is deregistered? Or
No,
did you get a message that your company is in the deregistration process?
yes, I logged in CIPC
Yeah.
and went through with my company number. And
Yeah.
when I checked it, it was just showing me that I can lodge the annual payment, and
No, no.
it is
No.
in the registration process.
Okay. If it's in the deregistration process, it still means that you have time to save your company.
Okay,
It means you have not paid your annual returns for the last 3 years.
okay, okay,
So meaning you owe us 300 rands
Ah,
plus
okay,
plus it means you owe because annual returns for anybody who's making less than 5 million a year, it's 100 rands. So you
okay,
owe us 300 rands plus the penalty of 150.
okay,
Now, if you can go back and pay that amount, then they will take it from the deregistration process. But however, another reason why it does not allow you is the issue the new issue called official benefit.
Okay.
Now you've got to complete that first before you file your annual returns.
Okay. Okay.
Hmm?
Okay. I'm listening, sir.
Yes. So you can drop me an email. I'll forward the email to the relevant section they will help you.
Oh, okay. Okay. And the other question is CIPC working hand in hand with SAMRO, or
Yes.
SAMRO it's another thing and CIPC it's another thing.
All right. I forgot to tell you when I was talking about collecting societies.
Okay.
SAMRO is a collecting societies registered with CIPC.
Okay.
We accredited them, we regulate them. It's SAMPRO and IMPRA and IMPOGOTO. So far, we've got 3 collecting societies that were accredited by CIPC. One is SAMRO, another is IMPRA, and another is IMPOGOTO. So they are
Oh,
regulated by us.
okay.
Yeah, they collect royalties for the usage of music by the users of the music on behalf of their members.
Okay. Okay.
Yeah.
Because I've already registered my songs with Samro, so I
Yeah.
didn't know that I need to register them with CIPC, or they are still fine with Samro.
Now, when you've got your song registered with Samro, one, they are going to make sure that they give license to radio stations to play your song. And
Yes,
every time a radio station plays your song, they must pay. We call it needle time.
Needle time. Yes, yes,
Yeah, not only radio stations, but retail stores like your Pick and Pay, your Edgar's. When they play music, they should pay for the usage of the music. And not only that, airlines, whoever use your music must pay. So what Sambro is going to do is they are going to give your songs to radio stations, to
yes,
retail stores to play. And over a period of 6 months or a year, they will collect those royalties. And then after a year, they will give you those royalties. In other words, they'll come back to you and say, Metro has played your song 500 times over a period of 6 months. This is how much
yes,
you get from Metro. This is how much you get from YFM. This is how much you get from all these radio stations and all these retail stores. That's why they distribute after a year.
yes.
Are you okay now?
And yeah, yeah, I'm sorted, sir. So I heard you talking about something like uh, a lyricist and a producer and somebody who bring in the melody and those kind of things.
Yeah.
So I want to understand on this part. I'm a lyricist, and I as well I give them the melody.
Okay.
So I want to understand my percentage on this one. I bring in the melody and
Yeah.
bringing in the lyrics as well. So
Yes.
meaning sit down. I'm sitting down with the producer, telling him this is what I want the song to sound. So
Yeah.
on that one, how are we dealing with the percentage?
Well, that is an issue between yourself and the producer. You tell the producer what you want because in that song, you are the owner of the lyrics. You are the
Yes,
owner of the melody. So when you are sitting with the producer, tell the producer what you want because you own 2 rights in that song. And then you
yes.
should make an agreement and negotiate. And that agreement must be written down so
Okay,
that tomorrow he must not change and say, this is not the agreement.
okay,
And then you can negotiate percentages.
okay,
Yeah, yeah.
okay. No, no, I'm covered, sir. Thank you so much.
It's a pleasure. Any other question?
So before I leave you, is it okay if we can get a copy of the slides as in a PDF just to familiarize familiarize ourselves with everything.
Yes. Tsepo is here with us. Tsepo will send you the slides.
Okay, cool. Perfect.
Because,
Thank you so much,
because
sir, for your time.
it's a pleasure. It's a pleasure. Tsepo's got your email and he will send you the slides.
Lovely. Great stuff. Great stuff. Thank you,
Yeah.
sir.
Are you there? Are you there, Tsepo?
Yes, I'm here.
I see there's a hand from Shami.
Could I drop my email down?
Okay.
Okay, I'm gonna put it in the chat there so then Tepo can take it from there and then just send it out if he's okay with that.
All right. No problem at all. I see there are a few hands. SMHMES, or are these old hands?
Good afternoon.
Good afternoon.
I wanted to find out when it comes to technology. So if I modify an existing technology,
Yes.
maybe I add a few features.
Yes.
I believe that will then become my technology, even though it was previously owned or rather registered by a different person. But because I've adjusted or I've added new features, can I register that? And perhaps if you can expand a bit on that process.
Yes, of course. That's a good question. If there is an existing technology and you do a modification or an improvement, you are going to apply for protection for those improvements. Those modifications are yours. Are you with me?
Yes,
are you with me?
Thank you. So yes, maybe just a follow-up.
You can claim protection for the modification on that technology.
Oh, okay. All right.
Yeah.
Thank you.
Thank you.
That's just one of the issues, and which I think when you speak about it's Mukhasa, when you speak about copyright issues, and
Yes.
which may be an example because there's one. Remember, there's a Vodacom issue. The difference now is not about copyright. Actually, it's both, but now it has reached an amount of being the settlement amount, which they've moved from the copyright issue because I think that has been agreed with the court to say the man owns that product that he introduced to Vodacom, you know. But then there's this one that I think we need also maybe to consider and maybe make follow-ups for us to understand. And it's happening in the country between what you used to know as your liberation movement and a party known as MKP. Remember, there's now the copyright issue because there's a claim that Mkhonto was never registered by the ANC. And there's a gentleman who registered it on behalf of anyone who wants to claim it, who took ownership of it, who's the sole owner, but claims to have sold it to the ANC and given them the rights, and it's still in court. So I was saying that we need also to check the outcome of that because it may give us an understanding of what happens in relation to copyrights, because it's just like the SAFA issue. Remember, there's a gentleman who said, no, I went through the system and saw that it was never registered. There was no ownership of this. Then he registered Mkhonto as his own, was his own. Then when the new party was formed, that's when he came to the rescue and said, I think about 5 years ago, he did give it to the ANC, but it's still a challenge to say that he must show the documents that were signed off to say he did release it and left to the ANC. I was just saying it's part of the things that we should be able to learn out of the copyright challenges that are there. Because one of an example that it links with what you were saying about the Bafana issue. It's similar.
Yes. Yeah.
Yes.
No. That's 100% correct. And thank you very much for that contribution, because we learn from these cases. Like as an office, please call me case between Moses Makate and Vodacom. We have been following that case since the beginning until now. You know, now it's at the Constitutional Court, and we think that's the final step. And Vodacom has lost appeals, and we know that Vodacom must pay him 5% of the total revenue generated by Vodacom by the Please Call Me since inception in 2001. We are watching that very closely. And as far as ANC and Umkhonto weSizwe's logos are concerned, we know it was in court, but we are also opening our ears because as government, we know what the law says. And we don't have the merits of the case between ANC and Umkhonto weSizwe, but we are keeping a close watch. And thank you for highlighting the fact that we should keep a close look on them because those are landmark copyright cases we can learn from. Thank you.
Thanks.
I see there's another hand, Elaine.
Hi, sir. How are you?
I'm all right, thanks. Yourself?
Okay. I registered the trademarks at our company. I just want to find out how important is it to select the correct class to register in? Should you just try and register in as much as possible, or should I just stick to what I think is the best for our company for that specific trademark?
Well, I think the first thing that you have to consider is if you have a trademark, the first thing that you have to consider, which class does it belong to? You know, we've got about 45 classes. If it's in the class of maybe, let's say, beverages like beer, it is important to register it under that class.
Okay.
And if you have another trademark that falls within the class of motor vehicles, it is important to register that class. So you will look at what you have, you will look at the classes that are available, and make sure you register each and every one of your trademark according to the relevant class.
Okay, perfect. Because I've been registering one trademark in like 5 classes because it like overlaps a bit.
Yes, make sure it doesn't overlap because those classes are clear and distinct.
Okay. Perfect.
Thank you.
Thank you.
Are we done, Evans? Mr. Evans?
Yes, thank you, Mr. Koza. If that's all you needed to do for the day, we thank you a lot. There was great interest shown in this workshop. Unfortunately, we had to schedule due to unforeseen circumstances, but that means we're going to have to have another one in the new year. I will liaise with Mr. Tsepo, and then we'll arrange it for sometime, probably February or March.
No problem.
Thank you. It was very insightful.
No, yes, we are always available for you. Thank you for the opportunity, Evans. Thank you, everybody. Goodbye.
Okay, then. Bye-bye.
Thank you, Hassan.
Okay, thank you.
Thank you
Tsepo.
very much.
Thank you, everyone. Cheers.
Cheers.
Thank you.
Emily, I see you got the hand up. Is there anything I can help you with? Emily?
Mr. Hassan,
Yes.
I just want to check if you said that there's going to be I see the recording. I just joined late because of the engagement. Where will it be on the same thing here?
The recording should be saved in the chat later.
The chat later. Okay.
As soon as I press end event, it will start uploading the recording.
No problem.
A lot of the times, students join and then they go do something else. So even though we're going to end the event, there are still going to be students in the meeting.
Okay,
That will prevent the recording from being ready. So it's safe to say by tomorrow morning.
Okay.
Have a look if you can get the recording. If you can't, if you got my cell phone number.
Yes, I do. That's right.
Drop me a WhatsApp and I will get the recording for you.
Okay. Thank you, Mr. Hassan. Thank you.
Okay.
Cheers.
Thank you.
Bye.
Cheers. Bye-bye. Right, Emily, you're not saying anything. I'm going to have to lower your hand. Right, if there's no further questions, we are done for the day. You are more than welcome to leave the chat.
Thank you, Mr. Hassan.
Okay, thank you.
Thank you, Mr. Hassan.
Okay, thank you.